Welcome back to Google class, that is online class. Dear students, how are you? Today I am going to discuss with Indian Penal Code. Okay, under section 354. 354 define assault or criminal force to woman with intent to outrage her modesty. Okay, and also explain that whoever assaults or use criminal force to any woman intending to outrage or knowing it to be likely that he will thereby outrage her modesty shall be punished with imprisonment of either description for a term which may extend it to not less than 1 year, okay, not less than 1 year, but which may extend it to 5 years and shall also be liable fine. Okay, here punishment area is not less than 1 year, okay, not below 1 year, but extended to up to 5 years. Okay, here the assault or criminal force to a woman with intent to outrage her modesty means it's clearly indicated. Okay, the provision of 354 further explained has been enacted to safeguard public morality and decent behavior. Therefore, if any person use criminal force upon any woman with the intention or knowledge that woman's modesty will be outraged, he is to be punished. Okay, in leading case in Vishaga versus State of Rajasthan, and another case and Apparel Export Promotion Council versus A.K. Chopra. So, in both cases, the Supreme Court held that the offence relating to modesty of women cannot be treated as trivial. In order to constitute the offence under section 354 of IPC, mere knowledge that the modesty of a woman is likely to be outraged is sufficient without any deliberate intention of such outrage alone for its object. There is no abstract conception of modesty that can apply to all cases. A careful approach has to be adopted by the court while dealing with the case alleging outrage of modesty. And essential ingredients of the offences under section 354 of IPC are under 5 points is available. The first point, that the person assaulted must be a woman. Okay. Number 2, the accused must have used the criminal force and on her intending thereby to outrage her modesty. Number 3, what constitute an outrage to female modesty is nowhere defined. Okay, the essence of a woman modesty is her sex. Number 4th point, act of pulling a woman, removing a dress coupled with a request for sexual intercourse as such would be an outrage to the modesty of a woman. And 5th point, knowledge the modesty is likely to be outraged is sufficient to constitute the offence without any deliberate intention of having such outrage alone for the object. Okay, here the intention is not the sole criteria of the offence punishable under section 354 of IPC, and it can be committed by a person assaulting or using criminal force to any woman. If he knows that by such act the modesty of the woman is likely to be affected, knowledge and intention are essentially things of the mind and cannot be demonstrated like physical objects. The existence of intention or knowledge has to be culled out from various circumstances in which and upon whom the alleged offences is alleged to have been committed. Even though it is true that the assault or criminal force to women is one of the essential preconditions for applicability of section 354 of IPC, but the same has to be with an intent to outrage her modesty or knowing it to be likely that he will thereby outrage her modesty. Neither the use of criminal force alone nor act of outraging the modesty alone is not sufficient to attract an offence under section 354 of Indian Penal Code. Okay, let's discuss about modesty of meaning. What is the meaning of modesty? That means the essence of a woman's modesty is a sex. Okay, the culpable intention of the accused is the crux of the matter. The reaction of the woman is very relevant, but its absence is not always decisive. Modesty is an attribute associated with the female human beings as a class. It is virtue which attaches to family owing to her sex. The ultimate test for ascertaining whether the modesty of a woman has been outraged, assaulted, or insulted is that the action of the offender should be such that it may be perceived as one which is capable of shocking the sense of decency of a woman. A person slapping on the posterior of a woman in full public glare would amount to outraging her modesty, for it was not only an affront to the normal sense of feminine decency, but also an affront to the dignity of the lady. The word modesty is not to be interpreted with the reference to the particular victim of the act, but as an attribute associated with the female human beings as a class. It is virtue which attaches to the female on account of her sex. And one case from the court in state of Punjab versus Major Singh. Okay, Major Singh. Here this case was discussed before the court. The 3 judges bench of this court considered the question whether the modesty of a female child of 7.5 months can also be outraged. The majority view was in the affirmative. Bachawat J on behalf of majority opinion as the offence punishable under section 354 of IPC is an assault on or use of criminal force to a woman with the intention of outraging her modesty, or with the knowledge of the likelihood of doing so. The court does not define modesty. Okay, what then is a woman's modesty? The essence of a woman's modesty is her sex. The modesty of an adult female is written large on her body, young or old, intelligent or imbecile, awake or sleeping. The woman possesses a modesty capable of being outraged. Whoever uses criminal force to her with intent to outrage her modesty commits an offence punishable, same under section 354 of IPC. The culpable intention of the accused is the crux of the matter. The reaction of the woman is very relevant, but its absence is not always decisive. As for example, she may be an idiot, she may be under the spell of anesthesia, she may be sleeping, she may be unable to appreciate the significance of the act. Nevertheless, the offender is punishable under the section. What under the section? Section 354 of Indian Penal Code. Okay. And another explanation about this section: an indecent assault upon a woman is punished under the section rape. Okay, rape is punished under section 376 of IPC, but the offence under the section is of less gravity than rape. Okay, comparison section 376 and 354 of IPC is comparing less punishment here. Knowledge that modesty is likely to be outraged has been held to be sufficient to constitute the offence without any deliberate intention to outrage modesty. In this case, the victim woman was brought into a room under false pretext. The room was locked from outside. Inside, she was forced to drink liquor, okay, and taking a photograph taken in naked state and raped. Okay, here all the participants were held to be guilty of outraging her modesty. Who is the participant here? Accused person. Okay, accused person is a participating person. That accused was punished by this outraging her modesty. Okay. Another thing, example, a person who is guilty of attempting rape cannot be allowed to escape with the lesser penalty of this section. Where the accused walked into the room where female child of 7.5 months was sleeping and committed indecent assault of the child. He was held to have committed an offence under this section as he had outraged and intended to outrage whatever modesty the little victim was capable of. Here their lordship of court, that is Supreme Court Judge, House of Lords, pointed out that the person is guilty of an indecent assault if he intentionally assaults the victim and intends to commit not just an assault but an indecent assault. That is an assault which right-minded persons would think is indecent. Accordingly, any evidence explaining the defendant's conduct, whether an admission by him or otherwise, is admissible to establish whether he intended to commit an indecent assault. Okay, in this case. So many cases available, example of this section also. And another thing, outraging modesty or rape. What is that meaning? Outraging modesty or rape? The dividing line between attempt to commit rape and indecent assault is not only him but also is practically invisible. Evidence of informant that when she went to house of accused, she found that the victim was sleeping on the floor and accused was lying on her. Okay, accused removed her knicker with a view to commit sexual intercourse. Medical evidence does not indicate as to whether accused has tried to force his penis inside the private part of girl but could not succeed. Now, the offence committed by accused did not amount to attempt to commit rape, punishable under section 376, and read with section 511 of IPC, 511 of Indian Penal Code, but was one under section 354. Though there was ample evidence that the victim was disrobed by the accused and thus the accused outraged her modesty, there was no evidence of rape. What will happen? The conviction under section 376 was altered to 354 of IPC. Okay, but in state of Uttar Pradesh versus Rajit Ram case, the Supreme Court set aside a judgment by which a conviction under section 376 was altered to section 354. What is that section 376? Punishment of rape. Okay, section 354 of IPC, what is that? Assault or criminal force to woman with the intent to outrage her modesty. Okay, now it's clearly explained. Altered and remitted the case back to trial court. The accused in another case had forcibly laid with the prosecutrix on the bed and broken her pajama, stirring but made no attempt to undress himself, and when the prosecutrix pushed him away, he did not make efforts to grab her again. What happened? It was held that it was not an attempt to rape. It was not an attempt to rape, but only outraging of the modesty of a woman, and conviction under section 354 was properly admitted. Okay, many cases available. We don't want to discuss many cases, just we have this type of enough cases. And another thing, the same thing, punishment enhanced by Criminal Law Amendment Act 2013. What will happen? By the Criminal Law Amendment Act 2013, while no change has been made in the definition of the offence, the punishment for the offence prescribed in the section has been changed by providing a minimum sentence of 1 year and maximum sentence of 5 years. That's all. And I will give you another case for this purpose of this section. Okay, so here, where the allegation was the principal of a school, okay, he misbehaved with the girl student. What happened? Misbehave means this case was brought before the High Court, declined to quash the FIR. FIR means first information report, though he was exonerated in departmental proceedings. Okay, and another thing here, accused school teacher, okay, had sexually ravished petitioner witness 1, and had outraged the modesty of not only petitioner witness 1 but of several other girl students of the school. Here the Supreme Court held that prosecution has clearly established commission of offence under punishable under section 354 of IPC and 506 of IPC. So far as offence punishable under section 376 of IPC is concerned, the basic ingredients are set out in section 375 of IPC. On a reading of the evidence of the prosecutrix, a case of rape has been established so far as respondent is concerned, where the prosecutrix has not stated specifically about the act but has loosely described as fondling. That means the Supreme Court altering the conviction from section 376 to 354 of IPC. Okay, and another example case here, victim deaf and dumb girl aged 13 years was lured by the accused from her house to a distant place. When family of a victim reached the place, the accused fled away, leaving victim who was weeping. Her clothes were soiled with mud and accused concealed it. So in this situation, this case was brought before the court. The accused was liable to be convicted under section 354 of IPC. Okay, so the accused outraged the modesty of woman. He was convicted under section 354 solely on the basis of the evidence of the victim. The court observed that normally a rustic woman would not come to the court to implicate a co-villagers if the imputation were not true. A victim under section 354 in the same category as an injured witness. Okay, her testimony was found to be reliable due to the lapse of 8 years since the incident. The accused was not sent back to jail. He was made sit to the court for 5 days. And another example case where a 9-year-old school going girl was criminally assaulted by the one accused, and then her evidence was corroborated and the accused had no explanation as to why she and her father would falsely implicate him. In this situation, is a conviction under section 354 was upheld. Okay, so many cases available. I think this case is enough for this section. Okay student, we'll go to another part, another section. Section 354, subclass A, subclass 1. What is that? Explain about sexual harassment and punishment for sexual harassment. Sexual harassment and punishment of sexual harassment. Okay, here a man committing any of the following acts. Four is available. Number 1, physical contacts and advances involving unwelcome and explicit sexual overthrust. Okay, overthrust or a demand or request for sexual favors. Number 3, showing pornography against the will of a woman. Or number 4, making sexually colored remarks, okay, shall be guilty of the offense of sexual harassment. That is section 354 subclass A, subclass 1. And then section 354 subclass A, subclass 2. What is that? Any man who commits the offense specified in class 1, that means 354 subclass A, subclass 1, that is class 1, okay, or class 2 or class 3 of subsection 1 shall be punished with rigorous imprisonment for a term which may extend to 3 years or with fine or both. And section 354 Subclause A, subclause 3 explain about any man who commits the offence specified in class 4 of subsection 1. What is that class 4? Making sexually colored remarks, okay, shall be guilty of offence of sexual harassment. That is explain about section 354 subclass A, subclass 4. Shall be punished with imprisonment of either description for a term which may extend it to 1 year or with fine or both. Okay, the new provision has its origin in the judgment of Supreme Court dealing with issue of sexual harassment in workplace. The suggestion given by Supreme Court got statutory recognition by an enactment of sexual harassment of women at the workplace. That means Prevention, Prohibition and Redressal Act 2013 was enacted, separate state act. Okay, and section 354 subclause B explain about assault or use of criminal force to woman with the intent to disrobe. Okay, what is that? Any man who assaults or uses criminal force, any man who assaults or uses criminal force to any woman or abates such act with the intention of disrobing or compelling her to be naked, what happened? Shall be punished with imprisonment of either description for a term which shall not less than 3 years but which may extend it to 7 years and shall also be liable with the fine. Okay, this new provision also has not been based on any recommendation but is in incorporation of the state amendment made by the Madhya Pradesh. Okay, and section 354C explain about voyeurism. What is that? Voyeurism. The act explained that 354 subclause C, any man who watches or captures the image of a woman engaging in a private act in circumstances where she would usually have the expectation of not being observed either by the perpetrator or by any other person at the behest of the perpetrator or disseminates such image shall be punished on first conviction with imprisonment of either description for a term which shall not be less than 1 year but which may extend it to 3 years and shall also be liable to fine and punished on a second or subsequent conviction within imprisonment of either description for a term which shall not be less than 3 years but which may extend it to 7 years and shall also be to fine. We have two explanations based on this section. So explanation 1, for this purpose of the section, private act includes an act of watching carried out in the place which in circumstances would reasonably be expected to provide privacy and where the victim's genitals, posterior or breast are exposed or covered only in underwear, or the victim is using a lavatory, or the victim is doing a sexual act that is not of kind of ordinarily done in public. That the explanation 2, where the victim consents to the capture of images or any act but not to their dissemination to third persons, and where such image or act is disseminated, such dissemination shall be considered an offence under this section. Okay, so this is a new provision prescribing an offence based on the suggestion of Justice J.S. Verma Committee, okay, constituted in the aftermath of the December 2012 a famous Nirbhaya incident. Okay, during the deliberations, the committee was surprised to find out that offences such as stalking, voyeurism, eve-teasing, etc. are perceived as minor offences even though they are capable of depriving not only a girl child but frail children of either right to education and their freedom of expression and movement. The committee of the view that it is not sufficient for the state to legislate and establish machinery of prosecution, but conscious and well thought out attempts are required to be made to ensure the culture of mutual respect is fostered in India's children. Preventive measures for the initial minor aberrations were deemed necessary to check their evaluation into major sexual aberrations. And the definition, this offense has the following ingredients. Number one, if a person either watches sorry, or captures the image. Number two, of a woman engaging in a private act. Number three, in circumstances where she would usually have expectations of, subdivided into one, either not being observed by the perpetrator. Number two, or not being observed by any other person at the biggest of the perpetrator. Okay viewers, we'll go to another section, the same topic, section 354 subclause D. This section explain about stalking, stalking. What is that? Here section 354 D subclause 1 explain about follows a woman and contacts or attempts to contact such woman to foster personal interaction repeatedly despite a clear indication of disinterested by such woman, or 354 subclause D subclause 1 subdivision 2 monitors the use by a woman of the internet, email or any other form of electronic communications commits the offense of stalking, stalking, stalking. And provided that such conduct shall not amount of stalking if the man who pursued it proves that, number one, it was pursued for the purpose of preventing or detecting crime, and the man accused of stalking has been entrusted with the responsibility of prevention and detention of crime by the state. Or the second point, it was pursued under any law or to comply with any condition or requirement imposed by any person under any law, or number three, in the particular circumstances such conduct was reasonable and justified. These are all under included section 354 subclause D subclause 1. Now section 354 subclause D subclause 2 explain about whoever commits the offense of stalking shall be punished on first conviction with the imprisonment of either description for a term which may extend to 3 years and shall also be liable to fine. And be punished on the second or subsequent conviction. Second time is doing same repeatedly. The wrong, second time or subsequently conviction with the imprisonment of either description for a term which may extend to 5 years and shall also be liable with the fine. Students, and let's discuss about this definition of this offense as the following ingredients. Number one, if a man follows a woman and contacts or attempts to contact such a woman, monitors the use by a woman of the internet, email or any other form of electronic communication, or watches or spies on a person, or to foster personal interaction repeatedly despite a clear indication of disinterested by such a woman. Sorry. So when despite a clear indication of disinterest by woman, if she is followed by a man either in person or through the electronic medium, then is guilty of the offense of stalking, 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 as defined in this above section. What is the meaning of eve teasing? I know this eve teasing is a familiar one. Many people knows eve teasing. Eve teasing today has become pernicious, horrid and distinguished or disgusting practices. The Indian Journal of Criminology and Criminalist, published January 1995, has categorized even eve teasing into 5 heads. Okay, what is that? Number 1, verbal eve teasing. Verbal means oral. Number 2, physical eve teasing. Physically, that particular person is touching her or misbehaving. Number 3, psychological harassment. Psychologically disturbance. Okay. And 4th point, sexual harassment. And 5th point, harassment through some objects. Okay. In leading cases, Visagas West State of Rajasthan was seen by the Supreme Court. Supreme Court has laid down certain guidelines on sexual harassments. And another case, Rupan Diyal Bajaj versus KPS Gill. In this case, Supreme Court has explained the meaning of modesty in relation to women. More and more girl students, women etc., or go to educational institutions, workplace etc., and their protection is of extreme importance to a civilized and cultural society. The experience of women and girl children in overcrowded buses and metros, trains etc. Okay. Now modern trends will be going on etc etc, means you have to fill in the modern sector situations or horrendous and painful orders. Okay. So what is the main Supreme Court guidelines on eve teasing? I just wanted to focus in this area because many victim persons were punished by this act, and many of the aggrieved person was spoiled her life also. Many many girl students have died based on this eve teasing also. Okay. In Outrage, one famous case, Outrage College nearby, I think so, 95 and 97. Student also died by the eve teasing. Okay, what is that Supreme Court guidelines on eve teasing? Here, before undertaking suitable legislation to curb eve teasing, that it is necessary to take at least some urgent measures so that it can be curtailed to some extent in public interest. So Supreme Court inclined to give the following directions. 8 directions is available. Number 1, what Supreme Court guided? All the state government. First point is, all the state governments and the union territories are directed to depute plain clothed female police officers and the precincts of bus stands and bus stops, shops, railway station, metro station, cinema theaters, shopping malls, parks, beach, public service means public vehicle service, places of worship etc. Okay, so as to monitor and supervise incidents of eve teasing. And number 2, there will be further direction to the state government and union territories to install CCTV in strategic position, which itself would be a deterrent, and if detected, the offender could be caught. The 3rd, person in charge of the educational institutions, place of worship, cinema theaters, railway station, bus stands have to take steps as they deem fit to prevent eve teasing within their precincts, and on a complaint being made, there must pass on the information to the nearest police station or women's help center. Number 4, where any incident of eve teasing is committed in public service vehicle, either by the passengers or the persons in charge of the vehicle, the crew of such a vehicle shall, on a complaint made by the aggrieved person, take such a vehicle to the nearest police station and give information to the police. Failure to do so should lead to cancellation of the permit to play. Okay. Section 5, fifth directions. State government and union territories are directed to establish women helpline in various cities and towns so as to curb eve teasing within 3 months. Sixth point, suitable boards cautioning such act of eve teasing be exhibited in all public places, including precincts of educational institutions, bus stands, railways stations, cinema theaters, parties, beach, public service vehicles, place of worship, etc. Seventh point, Responsibility is also in the passers by, and on noticing such incident, they should also report the same to the nearest police station or to women helpline to save the victims from such crimes. And the last point of guidelines, the state governments and union territories of India would take adequate and effectively measures by issuing suitable instruction to the concerned authorities, including the district collectors and the district superintendent of police, so as to take effective and proper measures to curb such incidents of teasing. Okay, I think now it's clear, students. We'll go to another section, section 355 of IPC. What is that? Define that assault or criminal force with intent to dishonor person otherwise than on grave provocation. And also explain that whoever assaults or uses criminal force to any person intending thereby to dishonor that person otherwise than on grave and sudden provocation given by that person shall be punished with imprisonment of either description for a term which may extend it to 2 years, or with fine, or with both. Okay, students, the intention of the dishonor may be supposed to exist when the assault of criminal force is by means of gross insults. An accused person while under trial struck a sub-inspector of police who was in the witness box giving evidence against him. It was held that he was guilty of this offense. Okay, and another section, section 356 of IPC, explained about assault or criminal force in attempt to commit theft of property carried by a person. And also it explained that whoever assaults or uses criminal force to any person in attempting to commit theft of any property which that person is then wearing or carrying, okay, he shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. And section 357 of IPC explain about assault or criminal force in attempt wrongfully to confine a person. What is that? It also a detail whoever assaults or uses criminal force to any person in attempting wrongfully to confine that person. Okay, what happened? Shall be punished with imprisonment of either description for a term which may extend to 1 year. Okay, extended to 1 year, or with the fine which may extend to 1000 rupees or with the fine. Okay, and the last section 358 explain about assault or criminal force on grave provocation. Okay, student, I am closing this session. We'll meet you again next video class. Thank you. Bye.